Hi, my name is Chung from Miami, Florida. I'm here with Professor Michael Vastine from St. Thomas University School of Law, and we were attending oral argument today before the United States Supreme Court in the Shular v. United States case, a case coming from the 11th Circuit, in which we co-authored an amicus brief with the Kurzban, Tetzeli, and Pratt firm, and we wrote on behalf of AILA, Americans for Immigrant Justice, and Catholic Legal Services. So, Michael, do you want to summarize the case for us today?
So Shular comes up in the ACCA sentencing context, and it raises the question of what is a crime that involves a serious drug offense. And Florida has a really unique statute, and so obviously it had to get to the court to get resolved because this issue has been bouncing around the 11th Circuit for some time.
So you're talking about it bouncing around the 11th Circuit. What were some of the cases that came up, and when did this start? How long have we been working on this issue?
Well, the situation started in 2002 when the Florida legislature passed a very unique statute, becoming the only state in the country that has a law in which a prosecution doesn't have to prove that a defendant had criminal intent to possess a controlled substance. And so there's been constitutional challenges and immigration challenges and obviously now criminal challenges.
And what were the cases that recently came up in the 11th Circuit? The first one being Donna WA.
So in the immigration aggravated felony context, the circuit agreed, and I think the Supreme Court would have agreed based on their comments today, that the Florida statute is very different than the federal statute because the federal statute requires that the prosecution, again, prove culpable mens rea, that is the intent, that the person was aware that they were possessing a controlled substance. Florida does not, so it couldn't be a drug trafficking crime aggravated felony.
Okay, and then on from there, we had the Donna WA case, and then where did we go from there in the 11th Circuit?
So still immigrants were being accused of being aggravated felonies under the other half of the definition, which is that the Florida offense, the question was whether the Florida offense was illicit trafficking in a controlled substance, which isn't defined in the INA. And so the Board of Immigration Appeals had said that they had interpreted the statute to say that mens rea on the illicit nature of a controlled substance is irrelevant to the aggravated felony, so people were still deported, even though the Florida statute is one of a kind.
And that case was matter of LGH.
Yes, and then the circuit upheld that same line of thinking in a case called Schwazelme.
Which petition for cert was denied in that case?
Yes, exactly. So thankfully, the court took Shular, so now we'll get the same question resolved, but in the ACCA context.
So once Shular's resolved, do we have any hope for the issues that are in Schwazelme, irrespective of whether we win or lose?
Yeah, I think it would be really, really helpful. It would open the door for us to reattack the illicit trafficking aggravated felony. So the issue here was whether the crime involved a serious drug crime, which is a pretty simple, similar inquiry as we have in illicit trafficking, which means typically what we want them to do is the court to do is say they have to canvass the 50 states, see what's normal, and then see if Florida matches. And we all know that it doesn't, which is why we want them to say that that's the test, because we're one of a kind. The government, the Solicitor General, was arguing that they want the court to say this is kind of amorphic, that involving a particularly serious crime is something that doesn't have to have the categorical approach. It just has to generally relate in order to a drug offense in order for the sentence enhancement of 15 years in this case of doing federal time.
So to summarize the mens rea requirement that you keep on referring to, that means in Florida, essentially somebody can be convicted but not even know what the substance was that they were convicted for. Is that correct?
Yeah, precisely. So there is no mens rea requirement. And if you want to say that it was innocent conduct, the defendant has to raise this as an affirmative defense in which they have to meet the burden of proof in demonstrating that they did not know, which has a whole host of problems.
So what is it that we want? What do we want the justices to do?
We want them to say that this is a true generic crime in which they need to look at the national norms. They look at the 50 states, they would say Florida's different, and end this question once and for all. Otherwise, if they ruled that mens rea is not necessary for these sorts of sentences, then other states could possibly copy Florida, which would not be good for anyone.
And as far as how the argument went today, how did you feel in terms of the questioning that the justices did, and how do you feel, were we successful?
It's really hard to predict, but I think it was not a bad day for Mr. Shular. I think he has a really reasonable chance of coming out ahead on this. The government wanted to say this is going to be impossibly complicated in the future if you have to look at each state and see how it plays into this calculus. And I think by the end, the justices said, no, you don't have to do that. We know there's only one weird state, and that's Florida, and that they could resolve this question once and for all here in Shular and say that criminal intent matters before you give criminal sanctions, and that would be a good day for Mr. Shular and the immigration bar.
So very exciting stuff for AILA attorneys, for the 11th Circuit, for all of us doing criminal and immigration issues. So we're looking forward to the result in this case. Thank you.